Good afternoon. Today again we're doing this episode for the purpose of covering what most likely are the most important things for people who have a pending application with immigration at this time. I'm specifically referring to the work permit or the employment authorization documents. The thing with the EAD or the work permit is that one is entitled to it if one has a primarily has a principal application that's pending with immigration. Now, for so many years, there were some issues as to whether one is entitled to it, when one is entitled to it, and when one could actually receive it. But lately, under the present administration, they issued a new regulation or policy regarding a work permit or the employment authorization document. Now, let me start with emphasizing that if you have a pending application with a work permit, you're entitled, principal application with immigration, you're entitled to a work permit. Normally, it depends on the kind of application that you have. You have asylum application, for which case you could apply for a work permit after the lapse of a certain number of days, for which you have to consult your lawyer because there's a specific time frame or element as to that. But let me just go straight to the general policy that has been issued lately under the present administration. Normally, the work permit is good for 1 year. You could renew it for another year. Lately, they issued a policy, and most likely this will be implemented moving forward starting October 1, specifically for adjustment application, not for everything else yet. So if you apply for a work permit based on an application for adjustment with the USIS in the United States, you are entitled to a work permit that could be valid for the next 2 years, unlike what's presently being done, wherein the work permit is only valid for 1 year. Now, on top of that, I'd just like to point out that once you renew the work permit and you filed a pertinent application, you have the receipt, and the receipt actually would inform you that while the application is pending for the renewal of the work permit, the old work permit shall be deemed valid for the next 180 days. Nevertheless, let me go straight to the point. Under the policy of the present administration, a work permit based on adjustment application starting October 1 is valid for 2 years. Now, the way I see it, and I just like to point out, it does not cover for everything else. So it could be that your work permit application is based on another application, not based on adjustment application, probably asylum, in which case they may just limit it to 1 year. Now, in addition to that, there's a special application I'd like to mention for EU visa. This covers people who were victims of certain certified crimes under the law, for which they could file a petition, because the rationale behind it is that they may be of help to the authorities in arresting, in going after miscreants or criminals, and on that basis they may be entitled to a self-petition, so to speak, once they will be certified by the pertinent authorities in the enforcement agencies of the government. They could apply for a EU visa, and once it's approved, they could get a green card. Now, the only thing is, under the previous administration, they could only get a work permit once the EU visa petition has been approved. Now, there's a problem to that because there are only a limited number of visas in 1 year, 10,000, and that includes the derivatives or family members, and in which case there's a 3 to 5 year waiting time, and in between they don't have any work permit or any other document that they could use for employment purposes. So under the present administration, what they did was issue a policy wherein starting October 1, most likely, the start of the fiscal year, people who applied for a EU visa may be entitled to work permit once their petition has been determined by USIS or by the service as bona fide. So what is a bona fide EU visa petition? Under the regulation is that it's a properly filed EU visa application. There's a biometric done already and the applicant's not deemed to be a danger to the community or to the national interest of the United States, and there's an attached statement as to the circumstances of the crime, the hardship, and the injury suffered by the said applicant. Presently, that's what constitutes bona fide application for purposes of a U visa. Now, let me backtrack a little. Before you can apply for a U visa, you need to be certified by the police agency or even by the pertinent enforcement agencies of the government. And once you're certified, you could apply for a U visa. Now, under the present rule, if the U visa should be determined to be bona fide, as I explained earlier, meaning there's a bona fide determination of your U visa petition, right there and then you are entitled to work permit. Now, under this guideline, the details of which might be thrashed out as we move forward, the work permit is actually valid for 4 years, not 2 years. All right, so now I've covered several work permits, as I mentioned. So it's very important for you to consult your lawyer and determine which case or category your application may fall into. So there's a 4-year tentatively validity of the work permit for a U visa that has been determined to be bona fide. There's a 2-year validity for the work permit based on the present policy for adjustment applications that are pending before the service. They define it as eligible adjustment applications that may be detailed into specific subcategories down the road depending on the implementing regulation. And obviously for the other work permits that may be filed that's not covered by what I've discussed so far, those work permits might be valid only for 1 year. It's a little confusing. That's why, as I said, please call your lawyer, determine under what category and what kind of work permit you may be entitled to. So, as I said, there's a 1, 2, and 4-year work permit validity. So please consult your lawyer regarding this. Now, also, lastly, in passing, I might discuss this for future reference. There was, before as of December 23, 2020, a blank space policy under the previous administration, meaning if you file an application that for some reason there's space provided and it has been left blank, your application could be rejected. So the problem was that those spaces provided were not even pertinent, relevant material to the said application. For example, if you have a middle name space in the said application, but you don't have that and you left it blank, they will reject it. They will reject it or deny even in some cases. So one is supposed to fill it out and put in not applicable or whatever is applicable to indicate that it's not applicable to your case, and not even material. Nevertheless, there's this blank space policy wherein such applications were rejected, and there's a settlement wherein right now people are encouraged and notified that until July of next year, those applications or petitions could be rectified in the sense that you could advise immigration that your application that was previously filed was rejected based on that blank space policy of the past administration. You mentioned the circumstances under which it was rejected, also proof that it was actually filed and rejected by the service, and other necessary documentation indicated in the regulation. The reason for that is that the actual date of filing actually makes a difference. For example, your children might have been minors when it was initially filed, and when it was correctly filed, they're already over age. There's a 1-year requirement for asylum application, for example, in which case you might have missed it because of that. And also, the initial filing of the petition or application was filed in such a way that it would have made a difference. For example, if you filed in January, it was rejected in March, you receive it and you refiled it in June, then technically you miss out on 6 months. And therefore, the priority dates in terms of the petition, if it's a family-based petition or even employment-based petition, could actually be altered and would really make a difference considering the load of applications that have been pending during that 6-month period wherein you missed out on the actual date. Now, with this policy, you could actually inform immigration when it was initially filed and which should have been accepted in the first place, in which case the priority date in terms of the asylum application, which would make a difference down the road once you apply for a green card, or application for family base, which would make a difference to your children also, whether they have age out or attained the age of majority, or in terms of priority date even, especially in countries where so many applications have been filed, where a 1 month difference of the initial filing or priority date would actually mean 5 to 10 years in some cases. So with this policy, you could advise immigration, and with that, the proper initial filing as was made before should properly be reflected on record, and the pertinent priority dates and ramifications or consequences emanating from such priority dates could be corrected in your favor. And also, lastly, I just wanted to know that in relation to this, even there's a new policy subsequent to this within the service, wherein officers were advised that if there's such a blank space in the application, they ought not to reject it or to return it to the sender or even deny it, especially if such application is not pertinent or relevant or material or important to the said application. Because from experience, all these things could actually be confirmed, affirmed, and corrected even during the time of the interview or by way of correspondence. So please be advised of these changes, consult your lawyer, be aware that these are changes floating out there. But at the end of the day, each application is different, circumstances are different as well, and documentation is also different from one case to the other. So please consult your lawyer, and if you have any questions, just give us a call. Trust your law office, and be safe. And I think that's all for today. Thank you.